right. Good morning, everyone. Thank you so much for joining us today. My name is Jiyae Hwang, and I am a senior associate at Scott Legal PC. So today we're going to spend some time talking about the visa options that are available for investors and each of these visas' rules and requirements. So just a few housekeeping items before we get started with the webinar. So some of you may know that our firm, Scott Legal, was founded on an E-2 visa several years ago. And our founder is actually in the United States on an E-2 visa and also has been on several different visas, including F1, TN, B, and H1B visas. So, as such, we do know what you are going through. This firm is a full service immigration law firm, and we do offer immigration services in a number of different areas, including E2, E1, TN, L1, family immigration, National Interest Waiver green cards, EB-1 extraordinary ability green cards, EB-5 investor green cards, and more. We have processed hundreds of E-2 visas, and we typically process E-2 visas that are higher risks, which mean with lower investment amounts. And we have processed at consulates around the world, but our primary two consulates are Toronto and London. So we will be continuing this webinar series, and we're doing at least 2 webinars a week on different topics related to immigration law. And at the end of this webinar, we will be sending out several useful tools to all participants. So first, we'll send you a copy of this PowerPoint presentation that we will go through. We will also send you a link that you can follow to download guides that go through the visa options in more detail. We will also send you a link that you can follow to sign up for the additional upcoming webinars in the future. And this webinar will actually be recorded and will be made available on YouTube. We will also send the link for that. And we do encourage you to subscribe to our YouTube channel and hit the notification button, as we do regularly upload a wide variety of immigration related videos that could be useful to you. Finally, we will also send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. So as for today's panelists, we are lucky to have Kelly Weiner, partner of Scott Legal PC, to present today, who has extensive experience in processing a wide variety of investor visa petitions. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started with the webinar. So let's start with an overview of the E-2 investor visa. So what is an E-2 visa? So a treaty investor E-2 visa is a non-immigrant visa that allows nationals of certain countries to come to the United States to develop and direct the operations of an enterprise in which he or she has invested. And by saying non-immigrant visa, this means this is not a green card pathway. However, as long as the E-2 visa holder continues to meet all the eligibility requirements for the E-2 visa, there is really no lifetime limit to how long you can stay on the E-2 visa, and you can continue renewing the E-2 visa for you to continue directing and developing your enterprise. So there are two major options that you have towards obtaining the E-2 visa. The first option is to purchase an existing business in the United States. And the second option actually is to start a new enterprise in the United States. So the investment will be, so if you're purchasing an existing business, the purchase price that you pay to acquire the business will be your investment. When you are starting a new enterprise in the United States, the money that you spend on the necessary costs of setting up the business such that it is ready for operation, that will constitute your investment. And it can include things like, business setup fees, legal fees, getting the office lease set up for the office space, if you require any business equipment, and if you spend funds purchasing that equipment, all of those expenses that are related to starting up your enterprise will be included in your investment amount. Now, in order to apply for the E-2 visa, there must be a treaty between the United States and the foreign country of which you are a national. And you can look up which are the treaty countries by Googling, treaty countries, Department of State, and you will see a comprehensive list of all of the countries that have signed such a treaty, such that are participants in the E2 program. But many different countries around the world actually do participate in the E2 program. Many countries in the Europe, Africa, Asia, Latin America, Middle East do participate. So this actually is an option that is available to a wide variety of foreign nationals. Um, Now, one thing to note is that what is relevant in this inquiry is nationality. And by definition, when we speak of nationality, it means, do you have a passport of that particular treaty country, right? So if you're a dual national, for example, of a treaty country and a non-treaty country, for example, you can actually use your treaty country nationality to qualify for the E2 visa. That can be a useful option for certain people. Now, it is important to note that regularly, sometimes the list of treaty countries are updated from time to time. So there are countries that are added, and sometimes there are countries removed from the list. So this is a living list that is updated from time to time. So definitely check the most current list when you're applying for the visa. Now, let's talk a little bit about the duration of the E2 visa. How long can an E2 visa last? So, the validity period of the E2 visa depends on the reciprocity schedule for your particular country of nationality, and you can also look that up on the internet. And for most countries, for many countries, you could get the E2 visa valid for up to 5 years, which can be very useful. Now, in the case of certain countries, the validity of the E2 visa itself can be as short as 3 months. Now, however, it is important to note that there is a difference between the validity period of a visa stamp, and the length of period that you're given when you're entering the United States on an E2 visa. So the length of the authorized stay. So even if the visa itself is only 3 months of duration, as long as you enter the United States within the validity period of the visa, you will actually be given 2 years at the time of entry to stay in the United States to develop and direct your business. So there is a difference between the visa stamp validity and the period of authorized stay, which you are given as an E2 visa holder, which is 2 years at a time. And when you do need to leave after that, and then if your visa stamp has expired, that means you will, go back to the consulate and apply to renew your E2 visa. So you can do it that way. And once you have the new visa, you can enter again and get the new period of authorized stay to develop and direct your business. All right, so now let's go through the E2 visa requirements. What are the eligibility requirements to qualify for the E2 visa? So the first eligibility requirement is nationality. The applicant must be a national of a treaty country. And I have explained that national in this context means that you have a passport of the country. And if you're dual national of a treaty country and a non-treaty country, you can use your treaty country nationality to qualify for the E2 visa. The second requirement is that you must make an investment in the U.S. enterprise that you are purchasing or starting. So what does investment mean? So investment means that you are placing funds at risk. And so, for example, if you are saying that you're starting up a new enterprise and then you set up a, enterprise business bank account, and then what you did is you just transferred your personal funds into the business bank account and say, okay, that is, my investment. Actually, just transferring money into the business bank account will not qualify as money placed at risk, because practically you can decide to pull out the money at any time if it is just sitting in a bank account. So in the context of starting up a new business, what we're actually looking for is money placed at risk in terms of being spent on concrete things. For example, if you actually paid for setting up a business lease? So you pay the security deposit, you pay the first month's rent, for example. Or did you actually purchase business equipment that you need, such that you actually spent the money to acquire those assets? Those kinds of concrete spendings we usually count as money placed at risk. Although there can be a little bit of a working capital that you can count. Usually, when we speak of investment, it means money placed at risk, where you show that commitment to start the business, such that it's you're doing more basically than placing money in the business bank account. Now, the other thing about an investment is that you must be ready to provide evidence regarding where the money came from. So that is called the source of funds inquiry. And the requirement is that the money comes from a legitimate source. Now, when we're talking about the source of the funds, really it can be any legitimate source. So, for example, if you've earned income through employment and accumulated savings from that, you can show your personal income tax returns to show that you have earned that amount of money through your employment. It can also be a gift from someone you know. Now, if you're using a gift, for example, we also want to go one step further and show where the person who gifted you the money earned that money from. So, for example, if you received a gift from your sibling and your sibling earned that money through employment income, we will show the income tax returns, for example, of your sibling that shows where the sibling earned that money. And we'll also show the trail of the funds flowing from your sibling to your own bank account. Sale of property can also be a legitimate source of funds. So if you sold your house, or if you took out a loan secured from, your residential property, we would provide that documentation to show the source of the money. Now, one thing to talk about loans. So if you take out a loan to use towards your investment, you can use a loan if it is unsecured, or if it is secured by property that is personal to you, that is unrelated to the E2 business or the E2 business's assets. So the only requirement for loans is that it should not be secured by the E2 business, or it should not be secured by the E2 business's assets. So as long as you can, secure it with unrelated property, you could definitely use a loan to serve as the source of funds. Now, the other requirement about the investment is that it must be substantial. And substantiality means that the amount of investment really must be enough to, reasonably get the business ready to, go up and running. And it really, what will be considered a substantial investment will depend on the type of business being started. So certain types of businesses, such as, consulting firms that typically require a lower startup range, the government will expect, an objectively lower dollar amount to be invested to be considered substantial, as opposed to, for example, a manufacturing firm or a restaurant, for example, that could require a higher degree of startup funding. Typical E2 expenditures include things that you would normally expect when you're setting up a business to need, such as inventory, business equipment, costs setting up a website, rent to secure office warehouse space, spending on marketing to, get the client pipeline up and running, any money that you spend on business entity setup, those kinds of administrative fees, you can add as typical E2 expenditures that are required to start up a enterprise. Investment when starting versus purchasing a business. So one option that is available to the scenario when you are purchasing a business to qualify for the E2 visa is that you're able to use an escrow account to place the money into, and with the sole condition that if you're approved for the E2 visa, the escrow will release the money to the seller. So that kind of functions as a sort of a what do you call it? A way for investors to hedge the risk that the visa may be denied, right? So if the visa is denied, then the sale, won't go forward because, the sole condition of the escrow is the approval of the E2 visa. So that escrow arrangement to hedge that risk, that is an option available if you're purchasing a business and using that as a basis for your E-2 visa. But actually, escrow arrangements is not an option that you can use if you're starting up a new business. So when you're starting up a business, you actually do need to make, the purchases and, put the capital at risk to qualify that you have made an investment. So the escrow option is one way to, reduce the risk of, visa being denied, and that can be one option you can rely on that particular scenario. So marginality is the next eligibility criteria we'll talk about. The business cannot be marginal, and that means the profit generation potential of the business, the revenue generation potential of the business must be greater than just enough to support an investor's livelihood and the livelihood of his or her family. So this typically means, the business must be able to hire U.S. employees other than the investor and their family. So this would, if you're starting up a new business, you would prepare a comprehensive business plan that will show the 5-year projections of what is going to be the profit, what is going to be, the expenses, what is going to be the revenues, expected revenues of your business, and, your hiring plan for the next 5 years. What employees will you hire to run the business? And how will you support, the salaries for those employees? So that kind of plan will be very important when you're applying for an initial E-2 visa to convince the government officer that the business will be more than marginal. The business must be real and operating. So this means that basically everything ready for a business to start operations, open its doors, is set up and ready to go. So that means either the business is already taking revenue or ready to start operating as soon as the E-2 visa is granted and the investor is able to enter the United States. So some tips to how to prove that is, show that, the setup of the business is, has been secured, such as having the commercial lease already signed for the business premises, having established the business entity, having the company website up and running. And if you already have contracts with customers for the business, that can be a very positive type of evidence. If you require any licenses to operate your business in a particular area, you should show that you have already acquired those licenses. Now, a couple of other eligibility requirements to go through. The applicant must be coming to the United States solely to develop and direct the E-2 enterprise. If you are granted the E-2 visa tied to a particular E-2 entity, you can't really work for other companies while you're there or set up side hustles or things like that. That is not through the E-2 company. And also, the government will expect that the applicant, as a treaty investor, will play a directing and developing role in the company, as opposed to, doing all of the on the ground direct services work. If it's a service-based company, the government will expect that the E-2 investor will hire U.S. employees to do that kind of work. Ownership. The applicant must own at least 50% in the E-2 company, and it is important that this majority ownership is maintained while you are also in the United States on E-2 status. And finally, as the E-2 visa is a non-immigrant visa, there must be a showing of an intent to return to the home country upon the expiration of the E-2 visa and upon, the termination of the E-2 business enterprise, the business project. All right, so let's dig in a little bit in more detail about the investment requirement for the E-2 visa. How much investment is enough? So there is really no specific dollar minimum that is written in the regulations regarding, the minimum investment requirement that they are looking for, but the amount of money should be substantial. And what does that mean to be substantial? Really, this inquiry depends on the type of business. Also, it depends on where you apply and the particular examiner who is looking in your case, and also on the overall strength of your case with regards to other things like real and operating marginality, things like that. So when we say the investment can be as low as 50,000 or less, we're talking about cases where you typically won't expect that high amount of a startup capital in order to get a business up and running, and that can be true for certain businesses like consulting type businesses, services based businesses such as an accounting firm, for example. When you're setting up an accounting firm, maybe you need certain things like a business space, a computer to run software maybe, and you could hire an employee to help with the work, for example. But you would typically not expect to, need to buy a lot of inventory or, buy expensive machinery for equipment, for example, if it's, a consulting type um, business. So definitely the inquiry is about what is the type of the business and what is the typical expenditures that is needed to really get the business to the state that it is ready to be up and running. Um, the proportionality test is what the government uses when they are comparing the amount of your investment versus what are the usual costs that is expected to establish that business. So for example, if you're applying for the E-2 visa with a large manufacturing company that would typically be valued at 10 million or more, and then if you spend 1 million towards establishing that business, that is only 10% of the proportion of the cost needed to establish that kind of business, but that would still, be considered substantial because the high cost of establishing that type of business. However, if it is a smaller type of business that typically requires under $300,000 to establish, the government would typically expect to see 100% of the costs required to start that business to already have been invested. And substantiality of the investment can also be supported by, if you can get a independent letter from a CPA, for example, describing the typical cost of setting up that sort of business and confirming that your investment is reasonably sufficient to meet that. That can also be one helpful way to bolster the evidence that your investment is indeed substantial. The final point to note here is that franchises can be a good option for E-2 visas. It is definitely a common way that some applicants like to proceed. And it could be good because any costs that you pay to the franchise to acquire the franchise rights and set up the business can be included in, your startup investment amount. And also you can get help from the franchisor in terms of, business operational manuals or procedures and marketing help and things like that can also help with marginality if the franchise is an established brand in that particular field. So that can be a good option and a common one that we see. All right, so let's talk a little bit about employees. One common question that we get when we, encounter people who are interested in applying for the E-2 visa is, do I need to hire U.S. employees? And the answer to that question is yes, eventually, you will need to hire employees in your business. And that goes directly to the marginality requirement that the revenue and profit generation potential of the business must be enough, not only to support the investor and their family, but also to generate U.S. jobs. So the E-2 business must either have the present capacity or the future capacity to generate enough income to support U.S. jobs. If you are applying for the E-2 visa as a startup, then it is okay not to have employees at the time you apply. However, it is important to provide that comprehensive business plan that will convince the U.S. Government examiner that your business will eventually be able to hire employees in the next 5 years of operations, ideally, and we recommend at least 3 to 4 full-time employees. So I have mentioned the business plan many times throughout when I'm explaining this, but the role of the business plan is definitely significant here. So if you are applying for the E-2 visa with a new business, definitely we would recommend submitting a comprehensive business plan to support marginality. Now, when you are purchasing an existing business, if the purchased business has been doing very well, and you can provide, evidence of existing employees on payroll, for example, through W-2 records, historically, or a current payroll, for example. And if the existing business has a very strong revenue generation history, you can show the business's corporate tax returns to show that. Then maybe you don't need a business plan, or maybe you can, prepare a more simpler version of the business plan, showing that how are you going to, continue the positive trajectory. But if you purchase an existing business and it has not been doing so well in the past several years, then it can really help your case to prepare this comprehensive business plan to show the officer how you're going to turn the business around to, get to that point of stable, non-marginal revenue generation and hiring potential. So the business plan can definitely play a big role, and it is nice to have a very strong executive summary in the front and the front few pages of the business plan to really highlight the strength of your business and its revenue generation potential. Because sometimes the government officers would skim through the couple of pages, so it is good to front load that information. All right, so now then we can shift gears to the other types of visas available for investors, and Kelly will take over and take it through that.
Thank you, Jiyae. All right, so we're going to talk a bit about the EB-5 requirements. The EB-5 is for a green card. So this is for people who want to live and work permanently in the United States, as opposed to the E-2, which we've been discussing, which is temporary. So in terms of the investment requirements, again, in contrast to the E-2, where there's kind of nothing about a specific amount, the EB-5 does have specific amounts that you have to invest, either 800,000 or $1,050,000, depending on whether or not you are investing in a targeted employment area. You have to invest into a new commercial enterprise. So this doesn't mean a brand new enterprise. What it means is an entity created after 1990. And you can either start a new business, or you can invest in a business as long as it was created after 1990. This means putting money into the business and taking some ownership. And we'll talk a little bit later about how that works in terms of trying to buy a company. So a targeted employment area, if you are investing in a targeted employment area, this means you can invest the 800,000 as opposed to the higher amount. A targeted employment area is an area that has an unemployment rate that is 1.5 times the national average, or a rural area. Also important to think about when your investment in contrast to retained earnings. So sometimes people say, well, there's a lot of retained earnings in the company, so this can be used as my investment. This cannot be used. So retained earnings cannot be used for EB-5 investment. The money does have to come from outside of the company. Let's talk a little bit about challenges for EB-5 direct investors. So one, the source of funds, this is a really key requirement for the EB-5. And although the E-2 has a source of funds requirement, the EB-5 requirement is significantly different. There is much more documentation you have to provide. For an EB-5 than for an E-2. So this is important to think about if you're somebody who wants to start with an E-2 and then transition to an EB-5 over time. You want to be planning from the beginning for that EB-5 source of funds requirements to make sure that down the road you can actually use that for EB-5. Because again, something that would be very approvable for an E-2 as the source of funds may not necessarily work for an EB-5. You might need much more documentation to support it. So that's an important thing to keep in mind. Also, for an EB-5, there has to be an equity investment. You can't have a debt arrangement, right? So this relates to one of the requirements that your funds be at risk, which we'll talk about in the next slide. This is something where there's kind of no ownership percentage for EB-5 direct investment. You don't have to own a specific percentage, but it does have to be equity that you own in the company. All right, let's talk a little bit about job creation. So one of the requirements for EB-5 is that you have to create 10 full-time jobs in the United States. These can be direct jobs, or if you are investing in a regional center, you can also use indirect job creation to meet this requirement. This is generally going to be evidenced by things like I-9s, payroll, W-2s, things that demonstrate you have that direct employment relationship, or if it's through a regional center, you can demonstrate, indirect, job creation, and the regional center will kind of provide the documentation you need for that. A detailed business plan is very important for an EB-5, and it should link the job creation to the business plan. So when you're putting together the financials, you want to be very thoughtful about how they're being described, and obviously show that the company is going to create the number of full-time jobs that are required. Um, and as I mentioned, in terms of documenting the full-time positions, you're going to need to provide actual documentation for that. Properly completed I-9s, proof of payroll. So you do want to make sure from a compliance perspective that you are, covering all your bases, that you're making sure that all the I-9s are completed in a timely manner, and that you have all those on file, for later in the process. In terms of how you are actually going to file the petition, there's kind of three stages to the EB-5. The first is the I-526. This is where you're going to demonstrate that your investment has a proper source of funds and has been put at risk. The I-526, we'll talk about timing, in the next slide, but can take quite some time to be approved. The next step is the I-485 or consular processing. I will also call this kind of the green card stage of the process. So after, the I-526 is approved, at that point, you can have the apply for the green card. Actually, you can, if a visa is available, concurrently file the I-526 and the I-485 if you're in the US in a valid status and if an immigrant visa is available to you. So there's a benefit there. However, even though you can concurrently file them, the I-485 is not going to be processed until after the I-526 is approved. So when the I-485 is approved, or if you go through consular processing, what you'll get is a 2-year conditional green card. Um, and then once that expires, you'll need to file the I-829 in the 90-day period before the conditional green card expires. The I-829 is where you're demonstrating that you have sustained your investment and also that you've created, the 10 full-time jobs. All right, let's talk a little bit about timing. So EB-5 timing is very long. This is not a quick green card category. Right now, reported processing times for the I-526 are about 5 years. For Chinese nationals, it's about 7 years. Even after that approval, we're seeing kind of another maybe 1 to 2 years for the actual green card stage of the process. So it's not kind of an instantaneous approval after the I-526. And then, the I-829, once that's filed, to remove the conditions on your green card, that can be another 4 or even 5 years to get that approved. So the length of time before you're actually going to have a 10-year unconditional green card in your hand is quite a while. That being said, once you get the green card at the I-485 or consular processing stage, and then during the I-829 while that's pending, you're continuing to have an extension of your green card. So you are in green card status during that time, but it can be quite a long time before you, have that, unconditional green card. Also important to think about kind of country specific quotas. So you always want to check the visa bulletin to see if there is an immigrant visa available in your category. Right now, the EB-5 is current, worldwide and for many of the categories. It is not current for people born in India or China in the unreserved category, although in some of the other, the high unemployment, rural, it is current in those areas. Um, you want to, in terms of at-risk investment, that's always, I think, one of the most difficult parts of these types of petitions is that you do have to put your funds at risk, which means they must be at risk of loss. So, debt arrangements guaranteed returns, which we'll talk about later, none of that is permitted in the EB-5 context. Um, and you have to either invest your funds or have the intent to invest. Like to give an example, There was a case called Matter of Ho. The person invested $500,000. They put it into a bank account. They did not spend anything. They had no commitments. The court said this is not sufficient. Does not show intent to invest. This will not work for the EB-5. Instead, you do need to have some amount that has been spent, and also a good idea to have some commitments. For example, if you have signed a binding lease agreement, if you have, employment agreements that show you're going to be paying out salaries, if you have contracts that have been signed for renovations, or committed funds, that go towards, the enterprise, those are important to have, when you're doing the EB-5. It's not going to be sufficient to just put the money in a bank account, or to have kind of one or two contracts, for small amounts. Um, Loans and gifts are permitted for EB-5. However, you are going to have to document the source of funds, and it's very extensive. So if you're getting a gift from somebody, before you do that, you have to make sure that person is comfortable providing all of this financial documentation, many years of tax returns, lots of documentation about any businesses that they're engaged in, because if you get the gift and they're not willing to provide that, you're not going to be able to move forward. Also important for loans, to know that the debt cannot be secured by the new commercial enterprise. So again, the funds, have to be at risk. If it's a personal loan that is secured by the investor's personal assets, that will work, but anything secured by the assets of the new commercial enterprise would not. Um, in terms of purchasing a business, and this something important to remember is that you cannot purchase a business if the money is going directly to the seller of the business. The money has to be put into the company. It has to be used for job creation. There has to be that linkage there. So if the money is just going directly to a seller, that's not going to work as an EB-5 investment. So also something to keep in mind, if you want to go from an E-2 to an EB-5 and you've purchased a business from a seller, the money that was paid to the seller is not going to be able to be used as EB-5 investment. Um, in terms of the investment structure and how much you have to own, there is no ownership percentage. It can even be a fraction of a percentage. Often in regional center arrangements, the percentage is very, very low. So there's no kind of specific requirement for the amount the way there is for an E-2, but you do have to have some small ownership percentage. And then in terms of guarantees, return on investment, you cannot have a guaranteed return on investment. That would, make the case ineligible for the EB-5. The funds do have to be put at risk. There does have to be this risk of loss. A guaranteed return would kind of cut directly against that requirement. All right, let's talk a little bit about some other visa types that can be very favorable for investors. So one is the National Interest Waiver. So again, this is a green card petition. So this is for people who want to live and work permanently in the United States. Because of that, there's a high threshold, to meet the requirements for a national interest waiver. You must prove this category is done under what we call the EB-2 category. That means there is a threshold requirement that you have either an advanced degree, meaning a U.S. master's degree or the equivalent or higher, or you can prove exceptional ability in your field. Exceptional ability is kind of slightly under the EB-1A requirements of, extraordinary ability, so a bit easier to meet, but still somebody who can show that they have achieved something substantially above that of others, in their field. You must show that you are engaging in an endeavor that has substantial merit and national importance to the United States, that you yourself are well positioned to advance that endeavor by showing, your background, your resume, your history of success in this area. And that based on those factors, the United States government should waive the normal requirement under EB-2. The normal requirement is that you have a U.S. employer that tests the U.S. labor market, that makes sure there's no other willing, qualified, and available U.S. workers to do a job. In this case, a national interest waiver, you're saying, I'm engaging in this endeavor. It is so important to the United States. It has such substantial merit, and I will obviously make this successful because I, have this history, this background. I can do this. Please waive this normal requirement. Another benefit of the national interest waiver is you can self-petition. So you do not have to rely on a U.S. employer to file this for you, which makes this a very attractive category for many people. As I mentioned, it is a green card category, meaning you can live and work permanently in the U.S. Right now, this category is backlogged worldwide. So that is something where if you were going ahead with this, type of application and you're currently living in the US, you would need to look at your underlying status and make sure that that, can either be extended or you have a plan for that, because you will not be able to kind of concurrently file the National Interest Waiver petition, which is filed on the I-140, with a green card application. So even if you got an approval for the National Interest Waiver right now, that doesn't give you the ability to stay in the US. You would also have to have some underlying status or leave the US until your green card category is current, and then the green card can be granted. Um, Something else that can be an attractive option for investors, or it was meant to be, but is very rarely used, is the international entrepreneur rule. And this doesn't grant any type of green card or even a visa status. What it grants is parole, and that's something that allows people to kind of stay in the United States and work at their business, for increments of 2.5 years. But it is, kind of it's not a very permanent status. And I think, it has been very underutilized, but part of that is because there's very high barriers to entry for this requirement. So, people can apply for this, entrepreneurs who are either living abroad or in the US. It's relevant if you have a startup entity that was formed in the US within the past 5 years. You have to show substantial potential for rapid growth and job creation. So this is where we're talking about those high barriers to entry. You have to show at least, $311,071 in qualified investments from qualifying investors, and there's very specific technical definitions for that. So it's not just that you can put that money in yourself. You can't. You do have to have kind of these specific companies, the majority, owned by, US citizens or lawful permanent residents. So there's just very, very high barriers to entry for this, this grant of parole. If you can, get it, then it can be used to kind of work at the company in the United States. So it is still available, but again, high barriers to entry, and not used very frequently because it does not provide any permanent status. And you're not even on a visa status when you're here. You're just on, a grant of parole, which means you're allowed to be in the United States, but do not have an underlying status. Something else, another visa type that can be attractive to investors, is the E-1 treaty trader visa. So this is a temporary visa similar to the E-2, can be, granted, depending on which country you're in. The length of the visa will be granted based on the reciprocity schedule, but can be renewed indefinitely. You can get this visa type by showing that there is substantial trade going on between the United States and the treaty country, so the country where you hold a passport. It is, there's kind of similarities to the E-2 in terms of how it's treated, but it is based on trade. So you don't have to have an investment. And there does have to be this relationship of trade with the home country. So for the E-2, the business is based in the United States. There doesn't need to be any international trading, but the treaty trader visa, you do have to have that, substantial trade, which means a continuous flow of numerous transactions over time. There has to be a traceable and identifiable exchange of goods or services. So that flow of trade needs to be, demonstrated and already in existence at the time that you file for this. The trade has to principally be between the United States and the treaty country. So at least, over 50% of the international trade that the company engages in, needs to be with the United States. Um, and the person also has to intend to depart the United States, at the end of the status. So again, it's a temporary visa. It is not, not a green card. Um, a couple of benefits to it over the E-2. So one is there's no requirement to hire employees in the US. So some people may have, you may have a very successful, company in your, in your home country, and you sell, lots of goods to the United States. You need to come periodically to meet with people, and it's kind of frequent enough. You don't want to use ESTA or the B-1 business visitor visa. The E-1 can be a really good option for this. You don't have to hire employees in the US. You don't even have to have a US entity. It's not required. But although it can be helpful kind of for tax and compliance reasons, so over time that can happen. Um, and also important, I think I mentioned this previously, but the trade can be for goods or services. So this is outlined in the regulations, and especially as kind of service-based companies, have kind of, risen a lot. Important to know that it doesn't have to be tangible goods. You can be trading in services. Right, so we've reached the end of the presentation. Let's see if we have So we have some questions here. Can business have financing from a US bank if the business costs 2 million and I put in 2400, would that be acceptable? I'm not sure. So I think, you can have a loan. It can be a personal loan. The loan cannot be secured by the assets of the E2 company. And I'm not sure exactly what this number is here. If it's, if it's either 240,000 or if you meant to say 800,000. Either way, if the business costs 2 million and that you've invested only 240,000 or 800,000, that to me does not, from a percentage wise, I think will not be considered substantial. So would not work. Someone said they're looking to get some insight on the EB-2 NIW program. So we did cover this briefly during this presentation. We do also have presentations that focus more specifically on the National Interest Waiver. So I would encourage you to check those out, either our live webinars or they're available on our YouTube channel. Additionally, if you email us, you can also get access to a free National Interest Waiver guide that goes over in detail the National Interest Waiver requirements. Jiyae, do you want to take
Yeah, yeah,
this
I
next
can do that.
one?
If we have an existing business, do we need to have employees W-2s, form W-2s from last year, or just show a salary slip after I took over 50% ownership? So I think this is referring to a purchase situation where you are purchasing an existing business, you're purchasing majority stake in an existing business, and using that as the basis for the E2 visa application. Yeah, definitely showing the business's Form W-2s from the previous year is a very helpful and important piece of evidence to show the business's hiring history, which can support marginality of, that the business is a non-marginal enterprise. So that would be preferable to have the W-2s. And for the profit generation potential for the future and the hiring potential for the future, a business plan could help to support that. If you have a gas station on one LLC, and if after some years we get more opportunities, can we buy another gas station on a new LLC if you are on an E2 visa? So that sounds to me, and definitely please schedule a consultation to, discuss a very specific fact pattern like that. But just a general, um, in general terms, the E2 business authorization is only limited to the entity, the exact entity that you applied the E2 visa under. So the E2 visa is tied to your original entity. If you want to set up a new business, and then if you want to get a new E2 visa tied to that business, you can maybe apply for a new E2 visa for that. And there can be ways to get concurrent E2 authorization. But you can't just start working for a new LLC while you're in the United States on an E2 visa approved under a different LLC. And this one I think was already covered. Under E2, will children attending university be treated as in-state tuition fees or as international students? So that one, I don't know the answer to. Maybe schedule a consultation with regards to E2 dependent statuses, and we'll go. Yeah,
Yeah, I would
yeah,
also say, because this does come up, so this is very state specific. So it's
right,
not something that we're generally able to advise on. I think usually it is based on residence. So it's something where you would have to kind of contact the state program and ask them what their residence requirements are. Because it's really not an immigration question so much as it is a question of what each individual state's requirements are for in-state tuition.
right. Okay. Under E2, does each employee need their own E2 with their own application? So yes, there is an E2 employee visa. You can bring in employees from your treaty country if they are working at a managerial level, or if they are an essential specialized employee. They will need to, put in an E2 employee application to get their own E2 visa for that. And we do have specialized webinars going over that one as well. So definitely be in touch with us and check out our other resources. Kelly, do you want to take the last one?
Sure. So it says if the setup of the business is done, the investment's been made, and there's still a rejection, what is the recourse? Funds are lost. What happens? So this is absolutely one of the very difficult parts of the E2. Unfortunately, it is a requirement that you put your funds at risk in the commercial sense. So this is what they do require. There's different things you can consider depending on your situation, right? So if you're somebody who is in a purchase situation where you are purchasing a business, you can use an escrow arrangement. That's really the arrangement that's the most protective for the investor, because rather than the money being transferred, to the seller, the money will sit in an escrow account. The sole like reason for release of the funds will be approval of the E2 visa, or if the E2 visa is denied, the money will go back to the buyer. So in that case of a purchase, you can often protect yourself a lot with the escrow arrangement. If you're starting up a new business, it's a little bit more difficult to protect yourself. Ultimately, part of the requirement is that you put the funds at risk and that you have that risk of loss. You can always try to apply again. So if you were denied, let's say you had 40,000 spent and 60,000 in the business bank account, and they said you haven't spent enough, you could go back, you could spend some more money, you could always reapply and try to get, the visa approved based on what was the reason for denial. If not, there's different things you can try to do to protect yourself, like obviously keeping all your receipts for any computers or equipment that could be returned or sent back, trying to have in your lease agreement maybe a provision that says, you can get out of the lease without any penalties if the E2 is denied. So there are things you can try to do to protect yourself, but ultimately, as part of the process, they do require that you put your funds at risk. So that is a risk the investor takes on.
All right, I can take this one. Is
Mhm.
applying for an H-1B visa an option while I file for an EB-2 NIW in order to be eligible to stay legally in the United States? And the answer to that is yes. So the EB-2 NIW, what you do is you apply for what is called an I-140. That is, a petition for eligibility for a green card, and you can do that in parallel with, an H-1B visa. The H-1B visa is a dual intent visa. So if you get a job offer from a U.S. Company, you can certainly, qualify. If you qualify for the H-1B visa, you can be on that while your EB-2 NIW is processing. Any salary requirements on an E2 investor? No, there is no minimum salary that is, required under the law. Obviously, the, salary or dividends will, I guess, must make sense in light of the business needs, but there is no hard and fast minimum that is required. If the applicant is a Canadian citizen and does not have a passport, is that enough to apply for the E2 visa? And the answer is no. You need to apply and have a passport in order to get the E2 visa. All right, so I believe we have answered all of the questions. Kelly, thank you so much for sharing your expertise, and I hope this presentation was helpful to everyone. Thank you so much for joining us, and I'll see you next time.
Thank you.